That is consolidated. There's two docket numbers. The first one, 362330, and the second one is 362331. Both involve people v. Demetrius Ivory. And I believe, Ms. Sharon, you have reserved time, and I think there was something going on yesterday, so we appreciate your ability to come today and make argument.
I appreciate the court's accommodation.
Sure. And I think we have, who do we have? Mr. Morton? Is that you?
Yes, Your Honor. Good morning.
Right in front of you.
Good afternoon, excuse me.
Okay, Mr. Morton, you are here to answer questions, correct?
Yes, I'm sorry. May it please the court, Brent Morton, Assistant Attorney General on behalf of St. Joseph County. We did not file timely and did not preserve oral argument, but I am here to answer any questions. Thank you.
Well, let's start. Ms. Sharon, you may proceed.
Thank you, Your Honor. Alona Sharon on behalf of
I'm sorry, Sharon.
That's okay. It happens all the time. On behalf of the appellant Demetrius Ivory. Before I get into the substance of my argument, I am getting over a raging sinus infection and my ears are plugged. So if I am yelling at the panel or not talking loud enough, can you please tell me, because my volume perception is really distorted right now. Okay.
So for the record, if we yell at you,
Yeah.
we're not mad. We're just trying to
Okay.
Help you here.
And if you see, I'm just trying to open my ear a little bit so I can hear a little bit better. But again, I don't mean to yell at you if I am, okay?
feel free.
Thank you. Your Honors, I know that you are all very familiar with the very lengthy brief and all of the issues. I am just going to highlight a couple points and respond to some points in Mr. Morton's brief. And of course, if the panel has any questions. I want to start out, and I may go a little bit out of order because I really want to address the issues that I think are most probative and the strongest in favor of Mr. Ivory. I want to start with addressing the issue of the statements of the doctor and the nurse and whether or not they were properly admitted under 8034, and whether or not trial counsel was ineffective for failing to object to those statements. First, I want to bring the court's attention to the recent unpublished case out of this court, People versus Holtman, Holtman, docket number 362520, decided exactly 5 months ago on March 7th of 24. The facts in Holtman are practically indistinguishable from Ivory on this issue, in the sense that in Holtman, the complainant in that case was sent to see Dr. Sims for an examination 3 years and 2 months after the alleged assault in that case. In our case, we have the complainants going to see the doctor 3 years after the alleged assault. And in Holtman, the panel in that case found that the statements to the doctor were improperly admitted under 8034, in large part due to the extended length of time between the disclosure of the alleged assault and the time that they see Dr. Sims. And also at that point, Your Honor, the investigation had already started. All the facts really that I argue in Mr. Ivory's case should lead this court to find that these statements are not admissible under 8034. So, and it's really remarkable how similar the timeframes are, 3 years and 2 months, and we have 3 years in our case. So I obviously was precluded from filing a supplemental authority because it's not a published case. And I understand that published cases are not precedential or binding, but this court has repeatedly recognized that even unpublished cases can be persuasive, especially where the facts are very, very similar in nature as they are here.
Did the doctor say anything in particular in terms of what the children may or may not have said? I mean, I get the nurse, because I think there were more direct.
I think both the doctor, and I do quote it in the brief, that both the doctor and the nurse repeat statements from the children, and the argument is both that the trial counsel was ineffective for objecting to statements from both the doctor and the nurse.
Okay.
The prosecutor here responds in two ways. One, to argue that Dr. Brown's statements don't fall under 8034. And I'd like to respond to that in two ways. One is this issue was obviously raised in the trial court in Mr. Ivory's timely filed motion for new trial. And the prosecution never argued that in the trial court. In the trial court, the prosecution argued that her statements, Dr. Brown's statements, were admissible under 8034. So to now raise this new argument before your honors that Dr. Brown's statements are not even hearsay, and so we don't even have to talk about 8034, that argument is waived because it was never raised by the prosecution in the trial court, and it's improper before your honors at this point in time. The second, my second response to that, with all due respect, is that I think that argument is quite ridiculous to say that Dr. Brown's statements are not hearsay and that they're not for the truth of the matter asserted. The prosecution tries to argue that her repeating the children's allegations were to explain to the jury the course of the examination and to put into the context the decisions she made when conducting the medical exam. I have never gotten that response from prosecutor before. I'm not even sure how to respond to it. But I think clearly both Dr. Brown's retelling of the complainant's statements to her regarding the nature of the sexual assault and the nurses clearly are for the truth of the matter asserted. And the question is whether or not they're properly admissible under 8034. And here where we have, it is indisputable that we have this massive amount of time, passage of time, that they've already spoken to a forensic interviewer. They're aware that there is a criminal case going on. And not only that, but that they are sent to the doctor at the behest of the prosecutor's office. And I'm going to get to that point in a second, that these statements do not come in under 8034, and that these children had no complaints of pain or injury or anything like that, that these statements do not come in under 8034. The last thing is that the prosecutor argues that the statement of the nurse, that the referral was not done by the prosecutor in preparation for prosecution. This statement and argument by the prosecution in this brief, Your Honor, is remarkable to me, because not only is it in plain language in the report from the doctor that these children were referred to her by the prosecutor's office, but at the motion hearing, and this is quoted in page 23 of my brief, when Ms. Zeiderveen was asked, how did this referral come about? All of her answers were very equivocal, as if she had no memory about how the referral came about. And that was when she was confronted by the language in the report from Dr. Brown that said clearly, with no ambiguity, that these children were referred by the prosecutor's office. And this is at page 23, that she tried to remember the circumstances of how the children came to see Dr. Brown, and that it was possible that the grandmother was upset that some of the children did not receive the same services as the other children. And quote, it may have been, end quote, that her office provided them with some options and told them the office could help pay for the co-pays. She noted that it was, quote, it was feasible and plausible, end quote, that her office gave them options to see a doctor, but it was not ordered. But when you take away all of her statements, she really has no solid recollection, according to her, which candidly, I found unbelievable, as to how these children came to see Dr. Brown 3 years later. So, Your Honor, I think that when you look at the holding in Holtman, where the court found that admission of these statements was error, and when you look at the really identical facts in Mr. Ivory's case,
Did Holtman grant a new trial?
It did. I think when you look at the decision, it granted a new trial. It first addressed, in Holtman, it first addressed an issue of prior bad act testimony that came in that wasn't proper, and it granted a new trial on that basis. But then it also addressed this 8034. And I believe that, I'm so sorry, and I believe that that admission of this testimony they found would have also been grounds for reversal as well.
What was the citation number? I
Sure.
have 362.
The docket number 362520. decided 3/7 of this year.
At one point in your brief, I read a quote, "The sum of trial counsel's errors prejudiced Mr. Ivory."
Yeah.
So
Yes.
it left me wondering if we have to find that all of the failures of trial counsel are necessary to be found to be below a certain standard, or if, we're focusing right now on one of them,
Sure.
if that's enough to get a new trial.
Sure. I think certain errors that trial counsel committed are certainly sufficient to warrant reversal on their own, and this is certainly one of them.
Okay.
And I think that this court has repeatedly acknowledged the danger and the prejudice of having an expert like Dr. Brown repeat these type of allegations, especially in particularly weak cases. And this is one of those cases, right? You have 3 very young complainants. Their testimony is very shaky, especially where you have 2 of the 3 complainants that are not even able to identify the defendant in the courtroom.
Well, I think that identification issue was interesting. And when you first read it, you're like, well, what is going on? But it does sound like he pretty dramatically changed it. Well, hold on, wait till let me finish before you tell me I'm wrong.
Sure.
Pretty dramatically changed his appearance, at least he cut his hair, and that I think he also went through cancer treatment. And so my guess is he probably lost some weight, which is pretty typical with that. So why am I wrong?
So for a couple reasons.
Okay.
One is, and this is not something that you can pick up on the transcript, but certainly from the video that was submitted to the court, you can. When the children are asked to identify Mr. Ivory, he's actually the only Black male in the entire courtroom. So that on its own is pretty suggestive and should have made it easier for the children to identify.
The kids may have just said, I don't see anyone in this room that looks like how, he used to look.
Sure.
Uncle D. So yeah, that.
But also, even if you look at the testimony from the various witnesses, and I do summarize this, it actually is in the section talking about the prosecutor misconduct. The testimony from the various witnesses is actually that his appearance hadn't altered very much, right? One witness testified that other than his hair, he looked remarkably the same. Other than his hair and his beard, he looked the same. There was only one witness who was of the opinion that his appearance had changed dramatically, and there is certainly no one who testified that his weight had changed dramatically.
Okay.
So I understand that that's an inference that Your Honor is making, and I certainly respect that. But there is witnesses were directly questioned about that, and no one commented on a dramatic change in his weight. It was either his appearance hasn't changed at all, and one witness who said, well, his hair and his beard has changed.
I just think, whether the acts took place, that is at issue with regard to your hearsay arguments. I think the identity issue's not quite as strong, only because there's no question that this gentleman was the Uncle D that everyone referred to. There was enough other adult testimony saying that's him, and the kids kept referring to an Uncle D. So to the extent that this was the gentleman who lived in the house for a certain number of years, I don't think was ever at issue.
Right. And I bring up the identity issue only for purposes of to establish that this is not an overwhelmingly strong case against Mr. Ivory. I hope the panel can appreciate that, right? There is no forensic testimony. It is a delayed allegation case. And their testimony in itself is not particularly strong. So to go back to your question, Judge Young, this error itself, I think, is enough to warrant reversal. The other error that I think is enough
When you
to
say this error, I'm sorry, where
error-
are we at again?
is the failure to object to the 8034
Thank you.
and the admissibility of that.
Sorry, just for clarification around that too.
Yes,
That is restating what the doctor and nurse heard from the complainants.
Yes.
Is that right?
yes.
And does that include or not include the use of the word abuse and the diagnosis of PTSD?
So this use of the word abuse is an issue that I have been trying to get traction in a number of cases, and so far have not had any luck, but I am determined to get traction in a case on this. And I understand that the case law that I rely on is somewhat distinguishable. I fully appreciate
You don't
that.
like the titles.
I'm sorry?
You don't like the titles. Because
I don't.
that's the person's title, but that's also, I think, your expert. That was in,
Well, not my expert, but yes, I do think it is prejudicial from the get, right? To call this person a child abuse pediatrician who then goes on to talk about the fact that he or she treats, right? Children who are victims of sexual abuse, because there's never really any clarification on the record that no, you treat children who allege that allege being a victim
but
of
wouldn't that be
abuse.
really easy to solve just by asking on cross-examination? Well, this is your title. This doesn't mean every person who appears before you is abused, correct?
It may
Yes.
be, but I also think the title itself is extremely prejudicial.
So, yeah, I have a question about that. So
Sure.
with the abusive head trauma cases, the ruling was that you can't give that diagnosis. And we know that there's the ruling, probable pediatric abuse
Right.
can't be a diagnosis. I don't know, so this question is not rhetorical. What was the professional's title in the like Ackley and abusive head trauma cases? Was it just doctor somebody, or did the title have abuse too?
That I don't know off the top
Okay,
of my
yeah, I
head.
don't know either.
I'm sorry.
Okay,
I'm
no,
sorry
that's
that I
fine.
can't answer that.
Yeah,
You asked me another question. Oh, did it also have to do with the diagnosis of PTSD?
yeah, it sounds like just repeating the statements from the children could be enough in your eyes to meet both Strickland standards. Is that fair?
I think it is,
Okay.
but I also think that failing to object to Dr. Brown's diagnosis, for which she has no qualifications, was also problematic, because when you then jump forward to closing arguments, and this isn't a footnote in the brief, and look at how the prosecutor used that testimony to bolster the complainant's allegations, right, to sort of tie together, she makes the statement like, it breaks their souls, it gives them PTSD, that type of statement. It's directly quoted in the footnote. She
I
tied,
agree that the doctor wasn't qualified to make a PTSD diagnosis, but I'm trying to fully wrap my head around the issue now that we brought up other diagnoses. So is the issue with PTSD the lack of qualifications of the doctor to diagnose it, or is it similar to abusive head trauma and probable pediatric abuse in that the diagnosis of post-traumatic stress syndrome implies the existence of a real traumatic event that has ongoing effects, which itself sort of adds credence to the complainant's testimony?
so it's the failure to object to her ability to testify to it without the
Okay.
qualifications. That's how it's raised in the brief. And then also, and the fact that his failure to object to it then allows the prosecutor to use that testimony to vouch for the complainant's credibility by saying, look, this is how being a victim of sexual abuse shows up in children, right? It causes them to have PTSD.
but to Judge Young's point,
Sure.
if in your eyes, this doctor was qualified to make a PTSD diagnosis, they had the specific, hypothetically speaking, they had this specific training, that was one of their specialties. Would it then be proper subject matter for testimony in a case like this?
I'd have to think about it, and I'd have to see.
I'm not asking you to put you on the spot.
No,
If you
that's
have a
fine,
firm view
but
one way or the other.
I think so much of it would depend on how much time the doctor spent with the complainant, what type of
Let's
workup.
assume did all the workup, did all the things. I'm just asking, do you have a view on whether PTSD is even a proper subject to bring up in sexual assault cases?
I'd have to, it would really be so fact specific to the case.
And that's
I mean,
fair.
that's really the best answer I can give you. But I think specific to Mr. Ivory's case, it was absolutely error, where she does not have the qualifications. And even more so, she wasn't even qualified as an expert in that area when she was qualified to testify. So I think all of that encompasses the error and the prejudice to Mr. Ivory. The failing to consult with an expert on forensic interviewing, memory, and suggestibility. I just want to respond to the allegation that the offer of proof is insufficient. So as court-appointed counsel, you know, I would love if every client could give me $10,000 to do my job in the best way that I can. But when we have indigent clients, sometimes the best we can do is offer a sample of the type of testimony that an expert could give, which is what I offered to the trial court and what is what I offered to your honors. But also Dr. Swerdlow-Fried is not a stranger to this court. And that is in part why I cited also In re Casto, which I think gives a fantastic summary and an additional offer of proof of his expertise and the type of testimony that he can offer in terms of forensic interviewing, memory, and suggestibility. But not only that, an additional offer of proof is within the footnotes where I meticulously, I will say, detail problems within the forensic interview of all of these children that are in violation of the forensic interview protocol. So it's not as if I have stood before this court or the trial court and said, hey, I think there's problems here and I want an expert, and the lawyer made a mistake by not consulting with an expert. I mean, to make that allegation is absolutely ridiculous. I've been handling these cases for 18 years. I know the forensic interviewing protocol like the back of my hand, and I can watch these interviews and know when there are problems. The fact that a diagram, about an anatomy diagram is used is in violation of the protocol. The fact that he doesn't set the rapport and the rules, the interviewers don't set the rapport and the rules, is a violation of the protocol. There are serious issues with these interviews, and there's a reason that these interviews are conducted in a certain way. And what is really problematic is that this lawyer, something prompted him to list Swerdlow-Fried on his witness list and then remove him without ever consulting with him, because no one ever argues that he consulted with Swerdlow-Fried. What the prosecutor does at the motion for new trial, which I am still offended by, is to suggest that instead of consulting with Swerdlow-Fried, the trial counsel consulted with Dr. DeGraw on this issue, which is so ridiculous.
Oh, hold on.
Dr. McGraw has a pretty extensive background. I'm sorry.
Well, I was just gonna say, I mean, sometimes when you list a witness, an expert, and then you don't call them, it's because you don't want to hear what they're going to say. I mean, it could be completely rational defense strategy to list someone on a preliminary witness list and then say, yeah, this is not going to go my way. I'm not calling this witness. Do we
Right.
have any indication one way or the other if that's what happened here?
Yeah, no, because according to trial counsel, and Dr. DeGraw refutes this in the affidavit that I submitted in the motion to expand the record, Dr. DeGraw told him there was no need for an expert in those areas. And Dr. DeGraw in his affidavit clearly says, I never reviewed these forensic interviews. That was not part of the record that I reviewed.
No. My point is different. It's defense counsel may have known what Dr. Swerdlow-Fried was going to say and said, I am not calling this person.
No, according to
Okay.
trial counsel and my conversations with him, he removed Dr. Swerdlow-Fried on Dr. DeGraw's advice, and
Okay.
Dr. DeGraw's,
And that's all you have to say. You don't have to
Yeah.
go further.
and that's fine. Thank you, Your Honor. And even if you look at Dr. DeGraw's testimony, when he's asked, what did you review? He never says he reviews the interviews. And Dr. DeGraw's expertise was specific to whether or not this notch or point of interest on one of the complainants, Hyman, was indicative of sexual abuse.
But I think we're getting into stuff that's very well explained in the brief
Yes.
and that we don't need to go through.
Sure, Your Honor.
So,
I have two very short things I just want to address.
okay.
The,
Question
excuse
really
me.
quick about this expert. So understanding
Which expert we talked about?
the Swerdlow-Fried.
Okay.
So understanding that the expert, or understanding that you've identified several issues with the forensic interview.
Yes.
How do we then connect this to prejudice? Or is your argument this is enough to get to a Ginther? Then let's figure it out.
Yes, Your Honor. If the court doesn't reverse the convictions on the 8034 issue, which I think is sufficient to, along with some of the other issues that don't require a Ginther, this court previously denied the motion to remand for a Ginther, but it was without prejudice. And I would ask that the court reverse its position on that and remand for a Ginther, instructing the court for funds to retain Dr. Swerdlow-Freed and to conduct a Ginther hearing on this issue, and any other issues raised in the ineffective assistance of counsel that the court thinks is appropriate. And that was just what I was going to get to. Also, the court previously denied the motion to expand the record, also without prejudice. And I think that the affidavit from Dr. DeGraw is absolutely crucial. And maybe the court feels that it was my fault at the time of the motion for new trial to not have something from him. But to be perfectly honest, I never anticipated the prosecutor to argue, in my opinion, such a disingenuous point that Dr. DeGraw would have reviewed the forensic interviews where that is clearly not in conformity with what his testimony was at the trial. The last point I wanted to make, which is very brief, Mr. Morton argues that in arguing that Mr. Ivory is entitled to funds for an expert, I don't allege his indigency. And I just want to point to the court that when the court appoints me as his counsel, that is a finding of indigency. And so I think that his indigency at that point on the date of my appointment, which was, I think, July.
I don't think this is going to rise or fall on whether
Okay.
your client is indigent or not.
Thank you, Your Honor. If the panel doesn't have any other questions, I will take a seat, and I'd ask the court either to vacate the convictions on the 8034 issue or reverse its position on the Ginther hearing issue and remand for that.
Any additional questions, Judge Young? Judge Kelly?
No.
Okay.
Thank you, Your Honors.
Mr. Morton, Judge Kelly, Judge Young, do you have any questions for Mr. Morton?
No, I'm good.
I don't.
Okay, we appreciate the briefing done in this case. It was very well done. Mr. Morton, we appreciate you appearing for questions. We don't have any questions. And I just want to thank Ms. Sharon for coming. It's clear that you're in a little bit of physical distress, and you've done a fantastic job by your client by appearing and offering what you have. So thank you very much for that.
Thank you for accommodating.